motion to bind over. I believe that the facts set up everything that's needed for count one, as it clearly shows that it's a substance, controlled substance, is cocaine. It was tested by the True Narc. In this case, Officer Hussein had testified about finding the narcotic residue inside the vehicle. Then the two larger bags, which were found at the hospital. In this matter, the defendant was the only one in the bathroom at the time in which these narcotics, or prior to these narcotics being discovered. He was informed not to flush the toilet, did so anyway, was also informed not to basically make sure that he could be visualized. In this case, he saw that he bladed himself towards the trash can away from the view. There was fervent movements with his hands. And then all of a sudden there happened to be, while he washed his hands, there's two baggies of one bag of cocaine, one bag of crack. It just happened to be wet at the time in which generally right after he washes his hands, Your Honor. So it's been tested and shown as far as count one is concerned. But when it comes to count two, Your Honor, I believe Officer Hussein's testimony is very relevant into the indications of narcotic trafficking in cells. It's our position, Your Honor, based on the fact that there was a scale there, multiple small baggies for numerous small baggies for packaging, tear-offs, which are commonly used as packaging, two different types of narcotics placed in two different bags, both of which are above the normal use for personal use. In this matter, we have one at 14, I believe one at 30 grams, Your Honor. One of those, I believe, which would be the cocaine, this pure cocaine, Your Honor, 30 grams, that's over an ounce. He had over an ounce of cocaine and then approximately half an ounce of crack cocaine, Your Honor, with baggies, with the scale. Those are every single thing beyond an address book that one would need for distribution, Your Honor. So we do believe that there is more than enough probable cause to sustain the additional charge that the people had requested, which was a possession with the intent to deliver, which would be a delivery of manufactured controlled substance less than 50 grams. We showed that the total weight of this was 45 grams, Your Honor, just under that 50-gram threshold, and that it was all cocaine or a mixture that contains cocaine, Your Honor. So for those reasons, and of course, we've already established venue, time, location, and identity. So, Your Honor, at this point, we do ask that the court bind over on the original count one and the added count two of delivery and manufacturing of a controlled substance less than 50 grams.
Thank you. The first element of this, of course, is that the defendant possessed controlled substance. In this case, the allegation is cocaine and crack cocaine. There was a pat down and a full search before the hospital, before any of these allegations happened, by trained law enforcement officers. They know how to do the searches. Well, Officer Colorasi was in training, but also trained to do a search, obviously. Nothing was found on my client's person, nothing in his system from the blood draw, no drugs, no alcohol. So really the possession comes down to these two bags that were found in the trash can in the hospital bathroom. A bathroom that is open to the public 24/7, doesn't require any special entry. Anyone could walk into that hospital and use that bathroom. I was curious how often they cleared the trash can, but the officer from the hospital didn't know. So obviously those bags could have been there for any amount of time. The officer from the hospital testified that my client had irregular hand movements, but at the end of the day, all he said was, well, he was drying his hands for an irregular amount of time or something to that effect. I mean, that's, I just don't think there's a lot there to support probable cause, respectfully. And no one saw my client put anything in the trash can. And of course, Your Honor knows there's two types of possession, right? Actual and constructive. Presumably the people are arguing both, that he actually possessed these, but, you know, that nothing was found on his person. Constructive possession is, of course, and then there's case law, I think Mr. Danner is aware of. There's Sixth Circuit case interpreting Michigan law, and there's the Michigan Supreme Court case. And I have the citations, I'll mention them quickly, but basically proximity to contraband is not sufficient proof for possession, for constructive possession. There has to be something else connecting a defendant to the contraband, whether it's a weapon or a controlled substance. And I won't go through a lot, but I would just like to, for the record, say that I'm referring to a Sixth Circuit case, Parker v. Renico, 506 F3rd 444, interpreting Michigan law, decided October 17, 2007. And that case cites many cases, including a Michigan Supreme Court case, People v. Wolf, WLFE 440 Mich 508, decided in August 31st, 1992. Very briefly, what the Sixth Circuit says is, as with the federal rule, a person has constructive possession if there's proximity to the contraband, together with indicia of control. In other words, proximity alone never suffices. Cites the Michigan Supreme Court case. And the ultimate question, according to the Michigan Supreme Court, is whether the evidence establishes a sufficient connection between the defendant and the contraband to support the inference that the defendant exercised dominion and control over the substance. That's beyond the mere proximity. So I respectfully assert that there is not probable cause on that first element for actual or constructive possession. The second element, defendant knew that he possessed a controlled substance. That would have to be inferred. There's no evidence of that. There's no statements or admissions. So that would have to be inferred from the first element. And, well, there is testimony of the weight. So that's the third element. So for all those reasons, well, I'll leave it at that. Thank you.
I really don't need rebuttal. The court would find that the people have sustained their burden of showing sufficient evidence that there's probable cause to believe that the defendant committed the offense of possession of a narcotic less than 25 grams. Also, given all of the testimony, in particular that by Officer Hussein, there is enough. This court believes that the defendant should also be bound to stand trial on the additional charge of possession with intent to deliver a controlled substance less than 50 grams. And so the court would bind the defendant over to circuit court on both those counts. The court would also indicate that the issues that are raised by the defendant with regards to those cases and actual possession, the court does find, for the purposes of probable cause, that those particular prongs under either test are met. To the extent there might be an argument as to what could be inferred or the intent, that this court would believe would become a question of fact that would properly be before the jury. But I think there's enough there to bind the defendant. Well, I know there's enough there to bind the defendant over. Defendant's bound over on counts 1 and 2.
Please subscribe to help the channel.
What started as a simple termination of tenancy dispute turned into something far more complicated and far more revealing. At the heart of this case is a rent-to-own agreement for a home valued at $450,000. The buyers, Mr. O'Donnell and Miss Bowers, claim they paid over $112,000 toward that purchase, including $85,000 in cash, while the seller, Miss Blair, disputes how much she actually received. There are charts, graphs, and exhibits waiting to be presented. There's even a photograph of Miss Blair sitting beside a large pile of cash, right next to what appears to be the signed contract. That's the kind of evidence that speaks volumes before a single word is uttered under oath. But the hearing couldn't move forward. Miss Blair arrived without legal representation, her attorney having filed a motion to withdraw just the day before. And the judge, though clearly frustrated, refused to let the opposing side present a full case against someone who couldn't defend herself. He was blunt about it. She caused this problem. But proceeding without her properly represented would create an appealable mess nobody wanted. So he granted the adjournment. Nobody liked it. Not the judge, not the plaintiff's attorney, not the witnesses who showed up under subpoena. What lingers here isn't just the legal maneuvering. It's the image of a locked-out family, a condemned house, disputed cash payments, a missed deposition, and a signed, notarized purchase agreement caught in the middle of a property that's now worth more than the agreed price. The stakes are real. The receipts are mounting. And the next hearing is set for June 28th. The truth has a way of coming out, one exhibit at a time. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.